Good morning, everybody. Welcome to today's webinar. My name's David Hills. We're going to give it a few moments whilst others join. So we'll stay quiet for a few seconds whilst others are actually joining the session. Okay, I think we've given people enough time. As I said, thank you very much for joining. My name is David Hills. I'm Senior Director here at ARC. Today's webinar is going to be run by myself. It's on navigating the building assessment certification process. We've got obviously the option to take questions right near the very end. So if you would like to ask any questions, please use the Q&A option. In addition, this is being recorded, so this will be available for anybody who wants to have access to it after the event. I'm going to start straight away then and get ourselves underway. Okay, so a little bit about ARC then. As I said, we're dealing with building assessment certification processes today. Just a little bit about ARC. We are a trusted partner for many organizations who are working in risk compliance and safety, and we've got over 25 years experience. And we're working at the moment with over 500 brands who trust us and are experiencing work with us, including a number who are going through the building assessment certification process at the moment. So we're going to be speaking to you today with a little bit of understanding about how people are going and what people are actually suffering or at least experiencing through that particular process. As I said, my name is David Hills. I'm Senior Director. I've been working at ARC for just over 24 years. And I am really focused on supporting clients through this whole process of building safety and the Building Safety Act. So what are we going to be covering today? I just want to do a very quick introduction. I'm then going to take you through how you would go about making an application for a building assessment certificate, what information is going to be required and how you're going to be able to present that. I'm then going to take you through what the regulator is tasked to do. We've had a number of conversations with the regulator, and so we understand exactly what they are looking for and what options they have to approve or refuse your building assessment certificate. We're going to talk about consequences right at the very end. I don't want to spend too much time on that because much prefer to focus on the positive side, but there are also negative sides in respect of this. I'm then going to give you some takeaways, and then, as I said, right at the very end, we'll take some questions. But before we do that, what I'd like to do is I just like to run a quick poll, if we can. So my colleague Rhiannon is going to actually just undertake a quick poll of everybody who's online. If you could answer, it would be very, very grateful. If you can't, it's not a problem. The question is, do you think you are prepared or ready for submitting your building assessment certificate if you were directed to do so? One is yes, we are fully ready. Two, yes, we are ready, although we still have a little bit of work to do. Two, although we don't think we're ready, but actually we could get ready if we were directed today. Four, no, absolutely no way are we ready, nor would we be ready if we were directed today. And five, we don't know. So it'd be welcome if you could select which one's the most appropriate to yourself.
We'll just leave it for a couple minutes and then get everybody's answers in, and then I'll read out the results.
That should be enough time, I would suggest, Rhiannon.
Okie dokie. So we have 2% of people saying that they are fully ready. And then we've got about 30% of people saying that yes, although we still have a little bit of work to do. 34%, sorry, of people said no, but they think they can achieve it if they got directed today. And then 18% of people say no, absolutely no way we are ready if we were directed today. And then 16% of people said I don't know.
Okay, fantastic. Thank you very much. I'm going to run the poll again right at the very end just to see if what we've done actually provides you with some information so you can determine exactly where you are. Okay, so let's just get straight in to the presentation then. Hold on a moment. Here we go. Okay, so very, very quickly then, as an introduction, following Grenfell, we had Dame Judith Hackett deliver her report, which has actually effectively set the scene for building safety ever since. And in fact, when you look at the legislation, everything about the current legislation is all based around the 53 recommendations that she made. Now, the effects of that report, as I said, has had a major impact on our legislation. In fact, we've actually had over 30 new pieces of legislation that have come onto the statute book, including the Building Safety Act and a whole host of secondary legislation. Now, out of that legislation, we have a new regulator, which is embedded within the Health and Safety Executive, and who is there to and is required to enforce that new regime. Now, the new regime itself actually includes a requirement that those who are accountable for residential blocks, and those are the blocks that are have 2 or more residential units or student accommodation that are over 18 meters in height or 7 or more stories. Now, those organisations, those accountable for those particular blocks, will be required, when they are directed to do so, to apply for what is called a building assessment certificate. Now, the building assessment certificate process is actually designed to actually determine if the principal accountable person is actually meeting their legal duties under Part 4 of the Act. Effectively, though, this is all about putting someone's name over the door. Effectively, how pubs and clubs are currently licensed. But instead of being licensed to sell intoxicating liquor on or off the premises, this is all about licensing to ensure that as a principal accountable person, excuse me, you are meeting your duties under Part 4 of the Act and that the building can be occupied. So that's the background to where we are in respect of building assessment certificates. So how do we go about making an application for a particular building assessment certificate? Well, under the Act, under Section 79 of the Act, the principal accountable person, not the accountable person, the principal accountable persons have a statutory duty to make and apply for a building assessment certificate. I'm going to call them BACs from now on, within a period of 28 days, beginning with the day that the principal accountable person actually receives from the regulator direction to do so. Now, we're already seeing the regulator ask for this from the beginning of April. Notification went out, and we are already seeing that the regulator is starting on a program of direction. What we are seeing, though, is that it appears that the regulator will be issuing those directions on the 3rd Thursday of every month. But prior to that, you would generally receive notification or advance warning, as they are calling it. So they are going to tell you maybe in advance that your particular property will be required to apply for a certificate within a period of time, 1 or 2 months. What I would say, though, is do not rely upon that. It's in place at the moment, but the regulator may decide that actually, do you know what? We've had enough time now. People should have got themselves sorted out. And so we're not going to give that advance warning. But certainly at the moment, that is how the regulator is acting. So you should not apply until you are directed to do so by the regulator. Now, that direction will come from the regulator directly to the principal accountable person. And normally, in normal circumstances, you would receive that as a principal accountable person via email. We have heard from a very, very small number of people that they've also received letters, but they are very, very rare, and it seems that they are actually only sent out if there is a clerical error. We would strongly recommend that you monitor the email address that you gave to the regulator when you registered the building, because that is very much how you are going to be told that you have to apply for that particular certificate. I think it's also very, very important that we understand that the 28 days starts with the day that the email was sent, not the day that the email was read. So if you are directed to do so without any reasonable excuse, if you fail to submit your application within that period of time, within those 28 days, you are, according to the regulator and according to the Act, committing an offence, a criminal offence. So, as I said, normally in most cases, organisations, if you're asking someone to support you, then if they fail to submit your application for you, then as a PAP, you will, though, be responsible for their failure. And remember, it's down to the PAP to actually ensure that you deliver that particular application. And the last thing I just wanted to mention, because it's very important on how this is seen by the regulator as well. Individual managers or directors within the PAPS organisation must ensure that they make every effort, or are seen to make every effort, to deliver the application when they are told to do so. Because what you don't want is to fall into a situation where you may be accused of either consenting or conniving or being neglectful, because in that instance, individuals can also be accused of committing a criminal offence. Okay, so what is it that you need in order to make your application? Most people thought that it's just going to be the safety case report. Well, yes, the safety case report is required. The most current safety case report is what you need to submit to the regulator as part of your application. Not the first report, especially if we are 2 or 3 years down the line. The regulator is expecting to see the most current one. The regulator is expecting to see not version 1, unless of course it's brand new. And at this early stage, we are certainly understand that they're very happy to receive version 1. In addition to the most current safety case report, you have to provide your most current resident engagement strategy. And again, same thing again, they expect your engagement strategy, depending upon the type of property that you have, to be reviewed on a regular basis. In addition, you have to provide information about your mandatory occurrence reporting system, the system that is available to residents and others, so that will allow them to report to you safety occurrences, issues relating to fire and structural risks. Okay, so that's the 3 basic elements, but the application also requires 3 other pieces of information. The first is that the regulator wants confirmation from you that the information held by them when you registered, or whether you gave them their key building information, is actually up to date. So this is actually an ideal opportunity for you to clarify that information that you provided during registration. You may have given the wrong information. You may have given information that was available at the time that has subsequently changed. In addition to that, if you have received a compliance notice from the regulator, and from our understanding, there are very, very small number of these, but if you have received something, then you should also provide the serial numbers for the compliance notices that have been issued to the regulator, by the regulator to you, that are currently in force. If they are finished with, you don't have to provide that particular information. And finally, you need to provide confirmation to the regulator that as a PAP, and working in conjunction with and in cooperation with other approved accountable persons for that particular building, that you have been providing and sharing building information to all of the relevant individuals, such as the residents, the owners, other accountable persons, fire and rescue services. Now, this information is actually pretty key. This information includes, for example, providing all of the residents and others with a summary of your safety case report, with a summary of your risk assessment, as well as not just holding your resident engagement strategy, but providing the residents with a copy of that engagement strategy as well. Okay, so we now know that when you've got to apply, we now know what information you need. Unfortunately, in order to make the application, as with the registration process, the regulator requires you to provide an initial application charge, and that charge under the Building Safety Regulator charging scheme is £288, including VAT. But it doesn't stop there. In addition to that initial application charge, the principal accountable persons will also incur additional ongoing charges that the regulator may apply. Now, these charges again are within the charging scheme and are currently set at £144 per hour. But, and this is really, really important, it isn't just based upon the number of hours that they are actually taking to review all of those 6 pieces of information that you provided them, because the regulator has the ability to call in additional advisors, call in other authorities such as the housing authority or fire authority or the police to obtain their views. And if those authorities charge the regulator, then they will transfer those charges over to you. In addition, the regulator may also call in additional advisors in respect of fire. So fire safety engineers or even structural engineers, they can call in and subcontract all of those people to support them through the application process. Now, you will not know how much they are going to ask you until you actually receive the actual invoice from the regulator. So you should be aware that the regulator is again regulated to ensure that they do not issue you with your certificate until all of the fees are paid in full. The unfortunate thing here is that you have absolutely no idea how much those fees are going to be. What I would say is right at the very, very beginning, back in 2022, when the Building Safety Act first came out, the regulator actually had estimated that it's approximately 70 hours of time for an average building that they will take. Subsequent to that, I should add that the regulator has withdrawn that from their website. So we have really still no idea how much the regulator will be charging. Once you've received your application certificate, you are therefore responsible to post that in a conspicuous location. And failure to do that, again, is a criminal offence. So failure to apply is a criminal offence. failure to actually have a building that's gone through the process without posting your certificate is a criminal offence. So we've got lots of things to actually consider here. We've got the application process, the information that's needed, and then of course the fees that you are going to have to pay for achieving that particular process. Okay, that's the application. What is it the regulator is going to be actually looking at? Well, the regulator actually has some very clear, distinct rules that it has to follow that are actually regulated within the Act itself. So under Section 81 of the Act, the regulator is required to assess whether the actual evidence that you have provided them or that they have gathered shows that the relevant duties held by you as a principal accountable person have been complied with, and in addition to that, they may decide to inspect your building in connection with that assessment process. Now, we have been told that it's going to be a rare occasion when the regulator inspects buildings, but the option is there for the regulator to do that. Now, I want to go through on my next slide the actual relevant duties, because that will actually determine exactly effectively a checklist that the regulator will be using to determine how well you are doing. But the regulator may gather their own evidence. It's not just about them relying upon what you are saying, either in respect of the documentation you provide or the information you provide. This again allows the regulator to actually undertake additional research to see exactly how well that building is and how well you are meeting your statutory duties. And again, failure to give them access, they may ask for additional information, and failure to give that information within timescales that they set is again a criminal offence. Okay. So what are these relevant duties? Well, effectively, the relevant duties are set out in Part 4 of the Act, and they relate to a number of key areas. First things first, you have a duty to assess building safety risks. Now, that's not just fire risks, it's the structural risks as well. So you have a duty to assess the building, and you have a duty to ensure that you undertake that assessment and ensure that they are suitable and sufficient. The regulator will be looking at those assessments. They may not ask for a copy. They may want to ensure that within your safety case report that you are referring to them and referring to the risks and talking about how you are managing that whole process. Because under Section 84, the duty is very clear that you have to, once you've identified the risks, you have to take all reasonable steps to prevent a building safety risk from materializing, and if they do materialize, reduce the severity of that incident resulting from that risk. In addition, you have to ensure that you take those steps promptly. Now, there is no definition of what prompt actually means. And in addition, you have to follow the management principles. And I'm going to go through the management principles very quickly in a few moments. You then also have a duty to make and give effect to a safety management system. So again, the regulator will be looking for evidence that you have that safety management system in place, that you have a duty to ensure that you produce your safety case report, and the regulator will be monitoring and reviewing your safety case report against some defined requirements set out again within the secondary legislation. In addition, you have a duty to establish and operate an effective mandatory occurrence reporting system, again, allowing residents to report safety occurrences. In addition to that, you have a duty to provide information to the regulator, to residents and other persons. And in fact, we've got a single piece of legislation called the Keeping and Provision of Information Regulations that sets out all of the different types of information that must be provided or must be made available if a regulator or a resident asks for it. And finally, at the end of the day, you have a duty to produce a residents' engagement strategy to promote the participation of residents and other owners, but it's not just about producing it. If you have a duty to provide information, therefore you have a duty to ensure that you publish that residents' engagement strategy. But it goes even further. You have a duty to act in accordance with the residents' engagement strategy. And so over time, the regulator will be looking for evidence to prove that you are acting in accordance with your strategy. Okay, I mentioned in respect of section 84 there that you have to take all reasonable steps, and you have to take all reasonable steps based around what's called the management principles or the prescribed principles. Now, when it comes to those reasonable steps, you have to follow these principles that have been set out in the Higher Risk Buildings Management of Building Safety England regulations, which is not easy to say, and which sets out the 10 layers of protection for life safety purposes. And the idea is to ensure that, for example, that we don't just rely upon a single protective measure, therefore a single source of failure, but looking for a holistic approach to building safety, looking at the whole building and looking and making sure that your management system ensures that you have multiple and numerous protective barriers in place to ensure effective building safety management. So what are these principles? The principles are actually relatively simple. First thing is you have to avoid building safety risks if at all possible. You then have a duty to evaluate building safety risks. So we've already mentioned the need to assess them. But you evaluate those risks that cannot be avoided and you identify the proportionate measures. You need to be able to combat building safety risks at source as early as possible to ensure that they do not manifest themselves. You have to ensure that suitable and proportionate systems are in place for effective maintenance of the actual system. You have to ensure and give collective priority measures collective protective measures priority over the individual measures. So that's really is trying to focus and move away from this rush that a lot of people did right at the very beginning of this process to a waking watch, which is an outdated mode, because ultimately we've got to move and adapt with technological processes. We've also got to, where possible, replace the dangerous with the non-dangerous or less dangerous. That's really focusing in on things such as having a look at the exterior wall, making sure that if possible we actually remove the dangerous or actually change it or actually assess it and determine if we've got a reasonable level of risk in respect of that. We've got to consider the impact on residents and ensure engagement. We've got to give appropriate instructions and information to our employees, to your employees, and to any other person who's working on, in, or around your building. And finally, we've got to ensure that any person who is responsible for or who is assisting you with compliance has the relevant competence. And this comes again back down to the principal accountable person. The principal accountable person must ensure that everybody who's working for them on their behalf is competent to do so. And therefore, anybody who's working on behalf of a contractor for them actually is competent as well. Now, the regulations basically say that if you're dealing with an individual, then what you're looking for is to ensure they've got the relevant skills, knowledge, experience, and behavior. If, though, you are talking about organizations, you may have hired an organization, you need to make sure that organization has the organizational capability to deliver the required function. There's a lot of material coming out in respect of this, and it's quite interesting on basically ensuring, for example, that if you've hired a fire risk assessor, does that organization have the appropriate quality measures in place? Are they, for example, BAFE certified or any other system certified? that will actually help you in respect of ensuring that that organization has the capability to deliver the required function. Now, these 10 principles mean that, as I said, that regime is forcing us to move away from short-term interim measures, really now focusing on the whole building. And now, although these are actually ordered from the most to the least effective, according to the government, the principles should not be considered in isolation. Many of them interact with each other and are mutually supportive. For example, a measure that you've put in place which may combat risks at source may also provide collective safety and may also need to be maintained and secured on a regular basis in order to remain effective. Relying, therefore, on a single protective measure or mitigation measure will not provide the multiple layers of protection that the regulator is expecting. And that's the reason why I wanted to mention the prescribed principles. When you're delivering your evidence to the regulator, it isn't just about providing a document. It's making sure that the contents of that document support your processes, support what the regulator is actually looking for. So they're the principles. What else will the regulator do? So once the regulator has reviewed your application, if they are satisfied that all of the relevant duties have been complied with, then they are duty bound under the Act to submit to you and issue you with a building assessment certificate. Now, if the regulator is not satisfied that you've met all of the requirements, then they have effectively got two options. They could firstly just refuse your application and then notify you of that refusal, or most likely, if the regulator considers that the contravention of that duty could be remedied pretty quickly, then the regulator may decide to give you a notice, what's called a compliance notice, containing a description of exactly what they are asking to do, but then specifying some very clear periods of time for remedying that contravention. So if the PAP then delivers everything to the satisfaction of the regulator within that period of time, then again, the regulator must issue you with your building assessment certificate instead of refusing that application. So quite complicated. So what I've tried to do now is just to set this out in a more graphical form. So let's just take us through the process very quickly again. You've been directed by the regulator to apply for your certificate. You've gathered and captured the information and the documentation you need. And then when you are directed to do so, you have submitted your application and your initial fee. What the regulator is then going to do is to take a look at that evidence. And if they are satisfied with the evidence and any other evidence that they have captured or asked you for, or even a site visit, if they believe that you are meeting the relevant duties, then they have a duty to issue you with your building assessment certificate, upon which you have a duty to display that assessment certificate in a conspicuous location, normally close to the front entrance. If the regulator is not happy with you meeting the relevant duties, then of course they can refuse the application. But most likely what they will do is they will issue you with a notice and again ask you to submit that information. Once you've submitted it, the regulator will then review that again. If they are satisfied, then again they will issue you with your building assessment certificate and you must post it in a conspicuous location. But of course, if the regulator is unhappy, then they again will refuse your application. And then we start moving into a different field, and that's where the regulator can take action to secure compliance. And for the last couple of slides, I just really want to talk about what the regulator could in fact do. So I don't want to spend too much time on this, but basically under the Act, the regulator has a duty to enforce the requirements. They can't just turn around and issue you with a refusal. They then have to take it to the next stage. And if they decide to do that, they will issue you with a compliance notice. and that will therefore ask you to ensure that any areas of contravention or any areas of potential contravention. So it's not just a case of, oh, we have contravened or we are contravening. There's actually the potential to contravene. They can serve a notice. So that's one of the first things that they can actually do. So where the regulator is going to do that, they're going to take you through the specific steps that you have to take and a specific period of time. And of course, they will ask you to remedy those matters that give rise to that particular contravention within a set period of time. But where it appears to the regulator that the contravention is placing or has placed or is placing people who live in or about that building in imminent danger, then the regulator may specify that the notice is what's called an urgent action notice. And an urgent action notice, as you could probably tell, means that you don't have as much time in order to get through this whole process. And again, failure to meet either a compliance notice or an urgent action notice is a criminal offence without reasonable excuse. Okay, so what are the consequences then if all else fails? If, for example, the regulator is unhappy with your approach, then this all else fails option actually allows the regulator, once they've gone through a tribunal process, and if they are able to show that there is a serious failure or that there has been a number of failures on 2 or more occasions, then they can ask for the tribunal to approve what's called a special measures order and appoint a special measures manager to undertake effectively the principal accountable person's role and ensure compliance, effectively meet all of those relevant duties. Now, as I said, this will be processed through obtaining what's called a special measures order. And the Act sets out some very clear requirements. An initial notice has to be submitted to a number of people before a final financial notice has to be submitted as well, because the special measures manager will act as if he was the owner of the building or the person, the principal accountable person. So they are there to meet the relevant duties, to secure the safety of residents and others. They can hold payments in trust, including income, and use that income to ensure compliance. And they can manage any contract that you as a principal accountable person has with a third party as if they were you. And again, this all comes down through a process, and it's an all else fails option. So with 2 slides there, I've just gone through the consequences. Let's just quickly finish off our flow chart here. So the regulator has decided that they're going to take action. So the first question they'll be asking is there a serious failure or is there multiple failures? And if the answer to that is yes, they will issue an initial notice to seek a special measures order to take that building and your building into special measures. If the answer to that is no, then the next question they will be asking is, do they believe that any person in or about the building is in imminent danger? If the answer to that is yes, they will submit an urgent action notice to take specified steps within a specified time. But of course, if that's not the case, then again, they will ask you to undertake what's called a compliance notice. And again, we would imagine longer periods of time in order to achieve compliance would be acceptable or expected, sorry, when a compliance notice is issued. So a lot of people ask me, what's the cost? What's it going to cost me if I get this wrong? Well, it's very, very difficult to give anybody an answer of that, because the PAP who, without reasonable excuse, actually commits an offence will actually be liable to 2 particular elements. On summary conviction, they could be liable to imprisonment for a term not exceeding the maximum summary term, or either way offences, and I'll go through that in a few moments, or a fine, or both. Or if they are convicted on conviction or on indictment, then they would that's open to imprisonment for a term not exceeding 2 years, or a fine, or both. But it's really important that we understand that in either case, if on summary conviction, you could also be subject to a further fine not exceeding level 1 on the standard scale for each day that that particular offence continues. So if, for example, you were found guilty on a Friday and you didn't do anything until the Monday, then effectively you have got 3 days of continuous fine, continuous contravention, which therefore means that you could be fined for that. So under the Criminal Justice Act, the maximum imprisonment term on summary conviction, so the first one, is 12 months for what's called an either way offence. And just to complete this particular part, level 1 fines on the standard scale are set at £200 a day. So going back to that example again, found guilty on a Friday, do with something on a Monday, that's 3 days, that's £600 further fine. What the fines, though, will be based around what's called the sentencing guidelines, and the Sentencing Council have produced guidelines, and they effectively say that every court must, in sentencing an offender, follow any sentencing guidelines which are relevant to the offender's case, unless the court is satisfied that it would be contrary in the interest to do so. Now, the factors that the sentencing guidelines use are based around 3 or 4 particular areas. First things first, culpability. So has there been a flagrant breach? Did the offender actually fall short of what's expected or appropriate standards? Did they mean to fall short? Or actually a lower level of culpability is the fact that actually, do you know what? It's an isolated incident. It's never happened before. In addition to that, another factor they will consider is the potential harm or harm caused. And finally, they will also look at other what's called statutory aggravating factors. And these aggravating factors are very worrying, because if they consider that you have these aggravating factors, then the higher levels of fines are going to apply. And aggregating factors could include, for example, cost-cutting exercises at the expense of safety, or the court believes that there's been a deliberate failure to obtain or comply with or avoid scrutiny by the regulator, or, for example, there's deliberate concealment or falsification of documents. So they're the consequences. They are quite wide-ranging and pretty concerning. So we've gone through the process of the application, we've gone through the information, we've gone through what could go wrong. That is really what I wanted to take you through today. So just as a takeaway, I just really wanted to give you a few of the conclusions before we run the poll again and then answer any questions that you may have. You should apply for your building assessment certificate when you are directed to do so, and make sure that you submit your application within 28 days. Please, whatever you do, keep an eye on the email address which you gave to the regulator when you registered your building, because that is how most likely your direction will come from. That you should ensure that your safety case report, that your resident engagement strategy, on your mandatory occurrence reporting system details are as close to being complete as possible before you are directed. And in addition to that, you'll also have other information to ensure that you are providing, including making sure that you are providing other information to residents and others as well. The regulator themselves has a set of rules to follow when assessing your application. It's not just about providing the information, it's about proving that you are meeting your statutory duties. It's about the proof, it's about what's contained within the documents. A document has never saved a single person, is what I remember one person telling me. It's what you actually do. And therefore, the regulator is interested in what you are actually doing. So make sure that your engagement strategy, your safety case report, is detailing that, is providing that evidence. And in addition, Once you've received your building assessment certificate, make sure that you post it in a conspicuous location within your building. Because of course, if the building regulator is unhappy, then as you saw, there is a series of enforcement action and approaches within their arsenal that they can use to ensure compliance, including, as I said, issuing notices and in the worst case, taking your building into special measures. Okay, so I want to run the poll again. So let's see if we can run the poll, Rhiannon. And this time it's just very simple. We want to find out, are you ready? Are you ready with a little bit more work? Are you not ready, but you could be? Is there absolutely no way, or actually, do you still not know?
So it should be on screen now, so I'll give you a couple minutes to fill it out, and then I can read out results.
Okay, we've got a reasonable number of people there, so
yeah. Let's just have a wee look. We've got some slightly different answers this time. So 5% of people now think that they are fully ready, which is a little bit of an increase on the last one. 43% think that they're ready, but they still have a little bit of work to do. While 33% think that they can achieve it if they're directed today, but they're not quite ready. And 10% say absolutely not. We are not ready if we get directed today. So there's a few differences in there. And now we can go through some questions. So we've got one question about the fees and charges you've seen from the regulator.
Yep. What's the question?
What fees and charges have you seen from the regulator? Sorry.
Well, we to be honest with you, we haven't yet. The regulator is taking its time before issuing the building assessment certificates. So we are all in the dark, as everybody else is. We just know how much they could charge. We are still waiting to find out how much those charges actually are.
Okay. There's another one here. Is there a timescale for the BSR to assess the BAC application?
Well, originally there was going to be. Originally the original guidance actually suggested, and the consultation suggested, that they would be asked to actually ensure that within a period of time between 10 and 12 weeks. But we still don't know. That was removed, so we still don't know how long the regulator is going to take, unfortunately.
Okay. And where a BAC is refused, does that place the HRB and the PAP into a criminal position?
Possibly, yes. Obviously, it will be subject to the approach and the method that the regulator decides to enforce the act. If they go down the notice approach, then you must be given time to deal with the requirements of the notice. Or they could decide to go down the more serious route of applying for a special measures order. All of those are criminal. The Act sits within criminal law. So if we breach or have a contravention of the Act, we are committing a criminal offence.
Okay, and then final question. Who would a special measures manager be? Would they be the regulator, or would they be an appointed managing agent?
That's a very, very good question. Nobody knows. The regulator hasn't disclosed how they intend to deal with that. I could be rather obtuse and turn around and say that probably the regulator doesn't know himself how they're going to deal with that. That's probably very unfair on the regulator. But basically, at the moment, we are awaiting it. There are people out there, there are organisations out there who do specialise in a liquidation. And we heard, for example, that they were approaching the regulator to, taking property into liquidation, managing property in that particular process. Those particular organisations were approaching the regulator to see if they were looking for support in respect of that. But it could be another managing agent. It could be themselves. We are all in the dark at the moment.
Another couple questions come through.
Okay.
Can you give an example of mandatory occurrences a resident can report and what system is deemed acceptable?
Well, it's very difficult to say what is deemed acceptable. It's got to be effective. So, for example, it could just be an email address that the resident actually uses to report a particular incident, or a helpline. It could be, for example, a specific technology solution. It could be a residence portal. The types of issues basically come down to whether they are fire related, and a safety occurrence has got to be a fire that has either caused the death of somebody or had the potential to cause the death of somebody. And a safety occurrence is also a structural failure that had caused the death of somebody or had the potential to cause the death of somebody. So a rather wide ranging definition of what a safety occurrence actually is. At the end of the day, it doesn't really matter what system you are using. It's got to be effective. So if you are, for example, using email and a helpline, then as long as that is effective, as long as you are dealing with that mandatory occurrence promptly, then the regulator will probably say that that's actually effective. It all comes down to how quickly you deal with a particular concern that's raised by a resident or another person.
Okay, and then I think we'll make this the last one. How long is the certificate valid for?
At the moment, the regulator has suggested that certificates are going to be valid for up to 5 years. But the regulator has the option to actually set a different frequency level. So it probably will come down to the level of risk and the type of evidence that you have provided. If that evidence, for example, relies upon a very large action plan, which is allowed, and requires you to actually go off and capture other information, then the regulator will expect you, or will probably issue a notice, a certificate, sorry, for a shorter frequency period. But just be aware that if you do have any changes to your building, or if you have any changes to your building safety case, then again, under the law, you must also notify the regulator. And it's at that stage the regulator may decide that they are asking you to reapply for your certificate.
There's a couple more questions, but what we can do is we will put them into a document and we can share them with you after the webinar, just so that we can finish up on time. Well, we're a little bit late, but...
Okay, well, thank you very much, everybody. I hope that's been of help and assistance. We are continuing to run a number of webinars, and all I would want to say now is just to thank you for your attendance and hope you have a great day. Thank you very much.